informed matter of President of the Republic of South Africa and Democratic Alliance and others for judgment.
Good morning, Justices. My name is Kelly Ngumalo. I'm a member of the Johannesburg Bar. I appear on behalf of the applicant in this matter.
Thank you.
Good morning, Justices. My name is Bongiwe Mkhize, and I am a member of the Johannesburg Bar. I appear on behalf of the Democratic Alliance in this matter.
Thank you. This is a judgment concerning whether the President of the Republic is under a legal obligation to disclose reasons for and the record of the proceedings relating to the dismissal of ministers and deputy ministers. The Democratic Alliance sought to reverse the President's dismissal of Minister Pravin Gordhan and Deputy Minister Mcebisi Jonas from their finance portfolio. In preparation for that application, it requested reasons for and the record of the proceedings relating to the dismissal. When the President failed to avail them, the Democratic Alliance applied for an order directing the President to do so. The High Court granted the order. The President then approached this court to provide legal clarity. While that application for leave to appeal was pending, the application to challenge the dismissal was withdrawn by both parties, rendering the pending application for leave to appeal moot. In a majority judgment authored by me and concurred in by Cameron J., Froneman J., Kampepe J., Ledwaba A.J., Madlanga J., Mtlandla J., and Teron J., we hold that it is not in the interest of justice to grant leave, not only because the issue is moot, but also because the order sought to be appealed against is interlocutory in nature, and it is ordinarily not in the interest of justice to entertain an appeal against an interlocutory order. The withdrawal of the review application, which would address the reviewability of the President's constitutional power to appoint or dismiss ministers and deputy ministers, renders it highly undesirable, and it is not in the interest of justice to entertain the application. This matter involves issues that are highly political in character. The nature of these issues demand a proper ventilation of facts attendant to them to do justice to those issues, much more than a mere reflection on how to construe Rule 53 of the Uniform Rules is required. A second judgment penned by my colleague Jafta J. and concurred in by Nichols A.J. agrees that the matter between the President and the Democratic Alliance is moot, but finds that it is in the interest of justice to interpret Rule 53 for guidance of future cases. The difference between the first and the second judgment flows from the exercise of discretion to entertain a moot appeal. In determining whether it is in the interest of justice to hear a moot matter, the court must take account of a number of factors, including whether the judgment will have a practical effect in future litigation, the importance of the legal issue raised, the impact or effect of the judgment on future litigation, and the wrong statements of law in that judgment. In finding that it is in the interest of justice to hear this matter, the second judgment holds that a judgment of this court would have a practical effect on the President and any other party who wishes to review an executive decision. It further holds that if the High Court judgment is left intact, the President would be placed in a difficult position in that once review papers are served on him, he is obliged to submit a record to the registrar. The High Court judgment is binding on the President, and without having it set aside on appeal, he cannot ignore that judgment. The second judgment further finds that incorrect statements of law in the High Court judgment also favor the adjudication of this matter. The second judgment further holds that this matter is of great importance to the public, not only because it involves a challenge to the appointment or dismissal from cabinet that governs the country, but also for the need to clarify procedural rights of a party who wishes to impugn these types of decisions. On the merits, the second judgment holds that the interpretation of Rule 53 requires us to look at the language of the rule, the context in which the rule appears, its purpose, and the material known to the Chief Justice in 1965 when the rules were made. The second judgment finds that a reading of the text reveals that the rule applies to specified bodies like inferior courts, boards, and tribunals, which perform judicial, quasi-judicial, and administrative functions. The President is not one of the identified bodies, nor does he perform one of the classified functions when he appoints or dismisses ministers. The second judgment concludes that Rule 53 does not apply to the review of decisions to appoint or dismiss ministers from cabinet. The second judgment would grant leave to appeal and uphold the appeal. In the result, the following judgment is made. The following order is made, I beg your pardon. 1, leave to appeal is granted. 2, the appeal is dismissed. 3, the President of the Republic of South Africa is ordered to pay costs of this application, including costs of 2 counsel. I hand down this judgment. Thank you. The court will adjourn.